Our speakers tonight, Trevor Dreher and Kathleen Davis. Trevor is a U of C graduate, and he joined Investors Group and went on to get his certification as a certified financial planner, and he's currently working with the Investors Group. Kathleen comes from U of C as well as U of A, and she started her own law company, KSD Law. And she did that in 2007 and has been specializing in real estates as well as wills, estates, and business law matters. What you're going to hear about tonight is why wills are important, the enduring power of attorney, personal directives, and how should contracts be handled. Trevor, Kathleen, you've done this before, haven't you? So yes, you're going to start? Yeah. Okay. So please welcome Trevor Dreher. Thank you.
One of the most interesting things when you're looking at actually planning for estates, does everybody remember Columbo, Peter Falk? Remember what he was famous for? Just one more question. And it would always solve the case, right? Just one more question. Well, here's the challenge. If you've passed away, we can't ask you that one more question. And that is one of the most interesting things in estates. This summer, one of my clients gives me a phone call and she says, "Do you have Dad's trust stock?" I'm like, "Well, I've got it accounted for, but no, we don't have it." She said, "Well, it's funny, we can't find it either. We can't see what company it's registered for." She phones me back the next week, and after going through his desk drawer, in a bunch of old papers was his stock certificate. Now, a lot of these papers were defunct companies and everything else, and here was the trust stock worth $270,000. If we hadn't done that detailed find 2 years earlier, it would have been very easy for that to have just got thrown in the garbage. That's probably the most extreme example I've ever come across, but it is actually, like this summer, real. So one of the things I'm actually starting with, my first part is, this is your chance to be Columbo. I really want you to take an opportunity to go through and make sure that in one place you've captured where everything is. I was inspired from this from my mom. She was dealing with a family friend, 92. And when she passed away, this family friend, my mom had actually been working with her for 2 years to get her estate in order, make sure they knew everything. Now, my mom is one of those people who dots every T, crosses, dots every I, crosses every T. And yet it still was impressive to her how much work the executor had to do in finding everything. So I'm going to have you open up the first lovely page. And the first page is all about you. It's things like your birth date, your social insurance number. It's very important things like who your advisors are, who your lawyers, your accountant, your tax preparers, your powers of attorney. These are all people who might need to be contacted. It is a lot easier if you're an executor, if you're dealing with an accountant who's actually done their taxes previously. And that's a really important thing. We go to employment information, and I deal mostly with retirees, so most of them are in fact retired, so employment information might not be so important, except where it comes to if you're collecting a pension. And then we go down to dependents. Who are your children? We're in an area of blended family. So does your stepchildren count? Do you have half siblings? Do you have adopted children? Are you including grandchildren as dependents in this one? It's really interesting when you actually think about that, and I'm sure you all have friends and family who are like, boy, if they had to draw out their family tree, it's going to take a lot of work. So that is a really important thing. The other thing is, this is also the point of a conversation where what child or two children do you want to actually maybe be handling your estate? Typically, we would suggest that you actually get a lawyers and accountants involved as well, but you definitely can have your children involved once they're elderly children. Cash flow. The only thing that we care about on cash flow on this thing is, where are your bills? So who do we actually have to notify that you've passed away? Now, I only have 2 actual bill payments that are not automatic every month. They're my Visa and my MasterCard. I would suggest, from dealing with clients for many years, that should probably be the extent of non-automatic bill payments. We're sitting down with a 90-year-old client and her son and I, and he's looking at his mom's finances. He says, "Mom, when was the last time you paid your $15 cell bill?" "Oh," she said, "might have been 6 months ago." $15 a month. Yes, It was a only phone out plan. Yes, he's like $15 a month. Where can I get that plan? So the point is, here was mom maybe wrecking her credit rating and doing other things and getting these notifications for a $15 plan. Put it on auto deposit. And that way, if someone's looking at your bank or your credit cards, everything would show up. You might have annual payments and other pieces that would be there. Those should also be accounted for here. Again, remember, your executor is going to have to get in contact with each and every company that you deal with and let them know of your passing. And if they don't know who you're dealing with, how can they do that effectively? If we flip over to the next page, this is one of my favorites. Not the one with my picture on it, that's also a good one, but the one that says assets and liabilities. Remember, no one knows you like you know you. And we all assume, and I hear this continually, my estate is simple. I love that. And then we find out about the antique car that one of them has, or grandma's quarter section of land that the wife has, and we find out that their estate is not near as simple as they think it is. So the big thing when you're looking at assets and liabilities is really accounting for, do you have every financial asset listed? If it's not in a document like this, it should be in a document where your executor would easily be able to go and find that. The first one is just banking institutions. If you hear very little else, please simplify the number of institutions you deal with. I had one client who was dealing with 6 different banks. I don't know why. They wanted to spread out the world and the wealth. But I'm like, how do you even track your cash flow on something like this? So go ahead.
I know why, because I was the executor of my father's estate in Lethbridge. And he was retired for probably 20 years or so. There was maybe 6 different types of institutions there, but guess who's on the other side of the counter? There's always a nice lady.
Nice.
So he did his rotation. And I had to go to every one of those institutions, every possible bank, to find out whether or not he had an account there.
That is a novel reason, and I think that's a valid reason, actually. There's nothing wrong with seeing nice young gentlemen or nice young women in terms of your encounter. For everyone else who maybe doesn't have quite as much time as your father had, really consider simplifying your time. You know, and that's interesting because that's definitely changing, and you can see that in the financial industry. The one-on-one contact, I mean, even my 80-year-old clients are doing their banking down south from, you know, over the computer. So that necessity isn't necessarily there, but I love that reason, actually. Thank you for sharing that. Well, it is. That's why it was a good story. Life insurance. It's so interesting, you know, when you deal with older clients, some of them have policies that they took out in the 60s and the 70s. And of course, if you follow the insurance industry in Canada, the company that they probably took that policy out has changed 3 to 4 to 5 times. Now the policy is still valid, but we just need to find out who actually is ownership of that. Like, where is the updated piece? And again, if you're alive, you can let me know. I have this policy. I think we took it out. Oh, was it Mutual Group? I'm not sure. Foresters? I'm not sure. Well, let's start looking for it and find out who would actually own that policy and get the right information for your executor. Non-registered accounts. You can have lots of different types of investments. And some investments are held at institutions. Some are exempt investments. You might not be able to hold them all at one institution. That's ideal for both yourself and for your executor. At the same time, you want to make sure that they're all on one statement with the companies who's actually holding those investments. That way your executor knows, okay, where am I going to look for Canada savings bonds? I haven't seen those in a long time. Business interests. If you do own a business, Kathleen and I were just talking about this before, and you're retired, you're probably following a lot of the rules that are changing with corporations and how they're going to be taxed, especially passive assets in corporations. It will be coming out in the budget at the end of this month. It could be very much a game changer whether you want your corporation to even last your lifetime. Forget about moving on to your estate. So the reason that you want to track these things is so that you're aware of them, and as things change, you might want to make changes currently. Registered investments, RSPs, RIFs, those are typically some of the easiest investments to deal with, from my experience, because they all have a beneficiary, even if it's a estate. They're the assets to disperse. As you know, in the death of the first spouse, it rolls automatically over to the second. It's just on the death of a second, it would go into the estate, and then your will is going to make the designation on what goes on. So, but those assets are typically very easy to find. Real estate, homes, cottage, farmland. What's the greatest tax exemption that we have in Canada, I would argue? Your home. But it doesn't apply to your cabin. And your farmland has different rules. And let's say you've had a cabin since 1970. Well, then you would have had some exemption because up to 81, you and your partner could have a principal residence. So you need a cost base up to there. In 94, you've needed to crystallize your capital gains. Many of you might remember that, right? In 94, you could actually crystallize gains. I know all this, you know all this, but would your executor be able to find those documents? Moreover, what if you've built your cabin? Let's say you bought the land for $50,000 and now the cabin's worth $500,000. Where are the receipts for your build cost? Like, how would I know what your actual cost base is into that? It's one of the biggest things I encourage my clients to do when they have a second property is let's go through, let's get an envelope, and let's start putting things in. Better yet, I said, let's take some time every year on an Excel spreadsheet to just update this and print this out or let your executors know where this is. And what's the advantage of that to you? Well, if you sell that cabin for $500,000 and you can only prove $50,000, you have a $450,000 capital gain. Might have $60,000 or $70,000 worth of income tax. What if you've actually spent $400,000 on that cabin over the years? You might have a $10,000 tax bill. Now, I know we all like the current government in this province, and we're very happy to give them more money at any point in our life, right? Yes? No. So, it pays to do your due diligence on this piece, and that is one of the most common ones. And farmland is equally important. I have a client and her family farmed on the land she's in, and if you're aware, if you farmed on land, it's in your family, then it's tax exempt, provided you can prove it. She's the only one with the records. So a number of years ago, we actually had her take it to an accountant with the records, and it's now in her estate to say, okay, yes, this is exempt farmland. Because if she would have passed away, there would have been no way for her children to find those records. So important on that piece. Other assets. Kathleen will probably talk about this, but there should never be other assets listed in your will. If you decide to give away your prize watch or mom's jewelry or the china, then what do I, the executor, do? I don't know, well, where did that go? Did it get stolen? Did it get lost? Was it pre-gifted? We often talk about including a list in the will with these pieces. Now, you might have some very valuable artwork and other pieces. They really should probably be dealt with separately, and there could be some exceptions always, like these are guidelines, not rules. Generally, though, it's a separate piece of paper, and that gives your executor the flexibility to say, well, if I can't find that, or if mom and dad already gave that out, that would be good. Just don't make it messy. Liabilities. Well, hopefully your person passing away won't have any, and this will just be the quickest page in the world. It might not be the case. And especially for credit cards, which they might pay off diligently every month, if you're not aware of who their actually credit cards are with, how do you know actually to notify and let them know and get those balances dealt with? So this is actually a very important part of your page in terms of knowing where the liabilities are. This spreadsheet right here will save your executor so much work. They might kiss you. No, they'll have to do that virtually because you'll have passed away. But I'm just saying it really is that important. If you've gathered this information, you've taken a big piece off their mind. The next page is just on insurances. Who do you have, if any, insurances? Knowing that your executors wouldn't have to look for them is actually a really nice thing to not have to worry about. So if you don't have any insurances, that's fine. You put a big X through the page, now your executor knows that. There could be, you might have long-term care, critical illness, you might still have disability depending, so those are nice things to know. Who's your home insurance through? Registered disability savings plans you may have. So that's actually really just some important pieces of information, and it's really simple because you probably know all this information. Last page. Do you have a will? I'm going to ask this question. Is anyone a journeyman plumber in here? Okay, I would never do my own plumbing. I'm not a journeyman plumber. The challenge with water is a little mistake can cause a really big accident. We were just talking about this with Kathleen before, but talking about a client who had a multi-million-dollar estate, and all of a sudden we're reviewing his will, and for some reason his socks are documented in his will, how many socks he has. It's just the craziest thing. And we get to the end, and he had done it himself. I'm like, that's crazy. That's just like me plumbing my own house. It just doesn't make sense. I'm not good at it. I don't do it. And a small mistake can cause a big accident. The good news about wills is I have a client, he's still alive. They have a will from 1967. We review it every few years. It's still valid. He's actually taken it to lawyers. Yeah, this still says what he wants to say, and he's never had to update it. Now, imagine you could pay for a service maybe 1 or 2 times in your lifetime and say, oh, that would be good. And that's the reason to get wills done properly. The other piece, though, that really matters on your wills is, what if you do need trust structures? If you're dealing with disabled children or grandchildren, you might need a disabled trust, Henson Trust. There's other trust structures that may make sense for your specific situation. And so paying for a little bit of legal advice to just make sure you're taking full advantage of the system here is a really good piece. Pension plans. Your Canada Pension and Old Age Security are relatively easy to notify. If you have a company pension plan or a couple of company pension plans, it's very helpful that your executor, if they haven't been accounted for elsewhere, is aware of them. If you're a subscriber for an education savings plan, and we do that for a number of our clients, children, they love their children, but they don't want their children controlling their grandkids' money, so they open the education savings plans as a subscriber. It's important that that we'd be aware of that, and that your executor would know, again, to notify that particular company. Tax planning, are your taxes up to date? Please make sure your taxes are always up to date. Al Capone, I was just watching, oh my goodness, what was that, Untouchables this weekend. What did Al Capone go to jail for? Tax evasion, not racketeering, not murder, not anything else, right? Now, Canada, we have a little bit more of a sense of humor in that area, but not much. So I would really just make sure that your taxes are up to date. When you put a document like this together, what I've found for most clients is interesting. You can probably get a B+ on this in about 10 minutes. That would mean you might not even have to grab any of your other documents, and just from memory, you could actually get most of this in. And you could probably get an A in a solid half an hour to 45 minutes. So for you, it's not a lot of work. This could save your executors months and months and months of drilling. I actually know some firms, law firms actually, if they have a good relationship with a financial advisor, actually request the financial advisor to come on the first meeting, because they usually bring all this information with them and just save them a lot of trouble and steps in terms of getting that done. So as you go on and plan your estate, it really starts very basically with just making sure that you've got it all in one place. Now, one of the most important things, and my mom and I always laugh about this because, as I said, she's very organized, she keeps moving her binder. So I said, where's the binder now? And she said, well, didn't I tell you it's in the bottom drawer of the office? No, it used to be at the top over in your walk-in closet. So when you've actually taken the time to do this, if you're comfortable, you could certainly give your executor a copy. There's certainly some people who definitely do that. I do family meetings all the time. If you're not comfortable, then you just want to let them know where these documents are. It's just very important that they're aware that you've taken the time to collect. Now, one of the things that will surprise you, is it often surprises me, let's say you don't do this exercise and you let it sit for 5 years. You would be shocked if you go in 5 years how many things you're crossing off. It is really amazing. We don't think about it because, oh, I changed credit cards because this one had a better deal. Or I changed banks because this one had annoyed me. And you realize that, oh my goodness, or you moved and you still have the old house, or you sold the cabin. So when you actually do a document like this, just every year, pick a date. I mean, tomorrow's Valentine's Day. I cannot think of anything more fun. I'm thinking of getting this for my wife. I think she'll really enjoy it. No, she won't. But I just pick a date, and every year just, again, update it. This will only take you minutes, and then you let the executor know where this document is. All of that is really important, because as Kathleen's going to talk about having your documents in place, I would just really emphasize, if your estate isn't organized before, having the best wills with all the things is really not going to be as helpful as it possibly could be. So before I introduce Kathleen, was there any questions just on this? Was there anything that had stood out or surprised you as you went through? Yeah, go ahead.
I'm surprised it doesn't make any reference to assets outside of Canada.
Ooh, there's a note section for that. That, and thank you for that, because that's a great example. When you do rules and guidelines, all of a sudden you're like, well, what about my, we had a client who had forestry rights in Romania, for goodness sakes, right? Yeah, so that's an excellent point.
I presume that both my wife and myself can fill one of these out independently, right?
You could fill one out as a couple, right? Like, if you love each other that much and you've been married long enough, you're probably okay. And there shouldn't be any surprises, for sure. I will say this, and I don't mean to underplay this, but I deal with this. I mean, I have an older client base. On the death of the first spouse, this is a very easy exercise. It really is. I don't mean to take the emotional thing. I'm just talking about the numbers. It's very simple. Everything rolls over. It's on the death of a last spouse, and when it's going over to children or charities or other places, that this gets very complicated. And most families in Canada, I mean, money is still kind of a taboo subject. We talk about sex more than we talk about probably money, right, in this country. So it's not surprising that maybe children aren't aware of where mom and dad's assets are. And this is a helpful document for helping them do that. Good questions. So one of the interesting things is you're seeing two different perspectives on this. You're seeing a financial advisor, and then you're actually seeing an actual lawyer who works in this area, which I think is really important. As I said, remember that journeyman plumber. There is a reason to get the right people in to do the right work. Well, you guys all have dealt with professionals, so we could all do our own operations and have decided that it's better to leave it in other hands. So please help me welcome up Kathleen Davis.
Good evening, everyone. I'm Kathleen Davis. As David mentioned earlier, I've been practicing now for 25 years and have my own law practice just a few blocks from here, actually. And so I want to talk to you guys about wills and enduring powers of attorney and personal directives. And then I'm going to save a little bit of time at the end to talk about just the estate process. And so here we go, and then we'll have lots of time for questions. Now, see what's happening here. Okay, so first off, I wanted to talk to you guys about a will. I suspect, first of all, let's do that show of hands. How many people have a will already? Well, I'm talking to the converted here. The interesting part of that is about 3 weeks ago, and I don't know where this statistic came from, but on the radio, for whatever reason, Alberta is one of the lowest compliance provinces for wills, and we don't know why that is, but maybe everybody's too busy being entrepreneurs or something out there. But I think the statistic, if I remember correctly, was 44% of Albertans have wills. And then that's shocking, but I have heard that before, so I don't think that's something new. That seems to be a fairly consistent number here. So in terms of the wills, of course, a will is a document that's going to be a legal document that's going to set out what happens to your assets and who gets them and what is the distribution at your death. And it's important because in the will, you're going to name right off the bat this person called the executor. The new language is now to call this person a personal representative instead of using the old language of executors or executrixes. And so that person is going to be in charge of handling your estate matters and your affairs, of course, after you pass. This group, you don't need to worry about guardian for children typically, but you may want to consider whether or not you're going to have someone being a manager of your child's money, or if your child is over the age of 18, still managing that person's money until they reach a certain age, or if you have disabled children, whether or not you're going to have somebody managing their money until the death of the disabled child. So those are some of the things that you would want to address in the will. Obviously, having the will avoids having the public trustee involved if you still had minor children. And if you died without a will, then underneath the Wills and Succession Act now, that act doesn't recognize people that you want to benefit from your estate. So for example, if you had a cousin, they not necessarily underneath those rules would your cousin get anything out of the estate. Charities, religious societies, any of those groups, of course, you wouldn't be able to give anything to unless you've actually gifted to those groups underneath your will. Common law spouses, unless certain criteria exist, so you want to make sure you've included that in to get your common law spouse included in as a beneficiary. Your friends and any other people out there that, again, you want to make sure get a gift underneath your will. So how I like to discuss things with my clients is I really try and break it down to simplify it. And that's not only for them, but for me at the same time. I have to gather a lot of information, as Trevor had mentioned. That document is golden to have that even for yourself, because as you know, the more you can kind of simplify your life and your assets, the better off you'll be as well. So I break this down into 3 categories for the clients, and I talk to the clients about the first category, which is anything that you own jointly. And so those kinds of things are a house where you have joint tenancy, but you can own a house a different way, and we'll talk about that one in a minute. But joint tenancy means if one of the 2 of you passed away, the property would go into the survivor's name. So there's an application you have to take down at the land titles office. You just have to produce a death certificate. You don't have to go through the courthouse. You don't have to go through probate on that. The second type, of course, would be things like bank accounts, where you would have joint ownership on bank accounts, some motor vehicles, depending on how you register. So that first group of jointly held assets is not even going to form part of your estate underneath your will. It's going to be exempted out. So the second go round for the second set of assets here is, again, that goes direct to the surviving joint tenant. And then underneath the second part is things that are designated by law or by statute that you can gift to other people. And so that grouping of documents and assets are registered retirement plans, investment funds, TFSAs. So you can go to whomever your provider is and make sure that you designate a specified beneficiary. So you have to be careful there, because typically if you are in a spousal situation, you're going to name your spouse. And as Trevor had mentioned, there's a rollover underneath those over to spouse. And when we talk about the rollover, what that does is income tax law says the moment before you die, then there's a crystallization of your taxation situation. And then there's always exceptions to that rule. And one of the exceptions is if you have specified your spouse as a designated beneficiary underneath the registered products, that registered product rolls over to your spouse and then is not taxed. The tax is deferred until the spouse starts drawing off that registered plan. And then at that time, that's where they're going to get taxed. So at least there's still tax payable, but it's a deferred tax as opposed to being taxed immediately upon death. The second thing that you can designate is the life insurance, and you can get a designated beneficiary through life insurance. And so again, you got to be specific about who you're putting in there. I would caution clients about putting minors in that life insurance, because typically they're going to receive that at the age of 18, and you may not want that minor to receive the life insurance benefit until the age of 25, and so therefore you might want to group the life insurance underneath your will. But if it's a spousal situation, again, you'd name your spouse there. And then of course certain pension plans, depending on who your employer was or is, and then whether they have a pension plan available. So that grouping of assets, again, by law, can go to the named beneficiary, directly to the named beneficiary. So the second thing, again, first one was the jointly held assets. Secondly is by operation of law. And those assets, again, are going to fall outside of the will. So then you're thinking, why am I doing this will thing in the first place? In the first to die situation, as Trevor mentioned, things are fairly seamless. There is the joint ownership, there's the designated products, but then you've got the third category, and for lack of any other words, I just refer to that as the other. And these are assets owned solely by the deceased that don't form part of the other categories. So those are things like real estate where you own as tenants in common. And a tenants in common situation is perhaps where you and your brother own a piece of property. It's been a revenue property for years. You own 50-50. Or sometimes I'll see on there you've co-signed for one of your kids and you had to co-sign on their mortgage, and you don't really want to have anything to do with their mortgage. You're going to be liable for the mortgage if they don't pay, but you have no interest in the property. You don't live there, you don't pay the mortgage. When I have clients coming in to co-sign for their kids, I put the child, and when I say child, I mean the child over 18, as a 99% holder of that property, and I put the parent down as a 1% owner of the property. And I do that on purpose because I want to do that in relation to the estate planning. If you die and it's a 99-1 situation, the 99% holder, that their estate, probably it needs to go to their spouse. If it was a joint survivor situation with a child and the parent who'd co-signed, if one of the two of them dies, it's going to fall into the other guy's estate, and that's typically not what we want to see on the estate planning. So there's reasons to do tenants in common. Again, usually revenue properties, sometimes cabins. You'll see tenants in common often on mines and minerals. So that's where we'll see that tenants in common, and you can't transfer over to a survivor. There is no such concept there. Things like stock options from, again, employment situations where you own stock in companies, and non-registered investments. If you've exceeded your registered amounts and allowances, then of course you might start throwing your investments into non-registered. Yes?
What if the non-registered investments are jointly owned?
It depends on the provider of those, whether or not they have that right of survivorship, and it depends on who you own with. So the law will say as between spouses, typically then there'll be that survivability by the spouse. But if for whatever reason your name's on there with one of your kids, the kid is deemed to be holding that in trust for the remainder of the beneficiaries out there. So typically with the spouse, but it does depend on who your investment portfolio is with. So they will have some sort of asterisk on that as to whether or not they'll allow that survivorship to go over there. So again, those are the three concepts that we have there, and that third category of assets will fall into your estate. So that's the one that will get captured by the will. In the situation, again, where it might be a couple in a first to die situation, those are the ones that are going to be found to operate underneath the will. So that's why you still need to have the will, because for any of these other things that fall outside of those first two categories, you need that will in order to transfer the asset over to the spouse. Yes?
Just one question on the revenue property. What happens if it's like actually two people owning it, but only one person is on the title of the revenue property? And how is that treated?
Yes, see, there is no ownership. So if you look at it from a purely legal concept, if there's only one person on title, they're the registered owner. So unless there's an agreement that's registered on the title that talks about some sort of co-ownership, or what's called a caveat, where there would be an interest in the land, a beneficial ownership in the land, then that one could be very difficult to prove. That if there were two people that actually were the registered owners, that would be a difficult proof if you didn't have some agreement in place.
Okay, but if you have one, then it's...
Yep, in fact, but I would probably want that, unless there were reasons by the lender that you couldn't put that agreement on, that I would suggest that you register that by way of caveat against the title to the property, because depending on which one passes away of those two people could have a real detrimental effect, because if you passed away and the other owner that you'd mentioned can't prove or establish their ownership, I mean, that asset is going to go into your estate, and now they're fighting with your beneficiaries, which are probably your immediate family members.
So as long as you have a caveat or a joint venture agreement on the side proving that there is interest in the property.
Yeah, it's still debatable, so that's why that joint venture agreement should probably be registered. Again, it protects the survivor's interest in the property as well, because again, there's only one person who can give evidence at that point in time, and that's the survivor of the two people. But that agreement, if it's registered on title, again, depending on other things that the lender may or may not allow, would be the best method for sure. Yep, it's just, and heaven forbid, I've dealt with this situation twice in 2017, and not prior in any time in my career, but just to mention some things that Trevor did just in the trenches. I've had two scenarios where the couple died together in the same car accident. So, and in that situation, the legislation has actually changed, and so they deem basically that, they used to say the younger of the two was deemed to be the survivor, and that the legislation has now changed to say, no, that's not the case. If you can't prove who died first, then they're deemed to have died at the same time, and then the estate is basically broken into a 50-50 scenario. So if they owned property together, like the matrimonial home, then that's broken into a 50-50 interest, and then it would flow through both of their estates. So that's where that agreement would be super important if those two people happen to be in the same accident at the same time.
And
in that circumstance, you're saying it must be on the title by a caveat?
Yeah, because the survivor can certainly transfer the lands. Like there, I guess, you know, there's obviously some very good implicit trust in this scenario that you're talking about, so I don't want to sound like such a naysayer out there, but there's nothing stopping that person who's on title today to transfer the title or get rid of the property unbeknownst to the other guy. But if that caveat's on title, that's what's going to stop something from occurring on the title without that caveat holder from knowing about it or being able to stop the transfer, the sale of the property. Okay, so when I talk about the estate now, we're talking about where does that estate go. So if you died testate, that means you died with a will. And what happens is sometimes then you're going to have to go get what's called a grant of probate. Now again, the rules have recently changed such that if the financial advisor, or depending on the types of assets that you have, you may not have to go and get this special thing called this grant of probate. That's an application to the court here in Alberta that basically codifies that this is the person's last will, and secondly confirms that the executor named in the will is actually the person that, again, the greater world is supposed to deal with. So I always think of that executor or that personal representative as a quarterback, and I kind of call them that because they're the person that is organizing all the financial affairs, trying to pull in all the assets and figure that out, and the liabilities. And they're also instructing various people. They're instructing lawyers and financial advisors and accountants and making decisions, but they should be hopefully delegating not their decision-making power, but they're delegating some of their responsibilities to have these other people assist them. At the end of the day, they're still the decision maker about what happens. So if you have to apply for this grant from the courthouse underneath the will, again, then it's called a grant of probate. And so the law will require that your expenses be paid out first, and the big expense usually is Revenue Canada underneath that, your debts and your taxes, and then the will look at if there are any specific bequests. So those are things like specific chunks of money given to beneficiaries, so $1,000 to grandchildren, jewelry, artwork. Again, there's biases that all lawyers will have in their drafting, and I can tell you my bias is that I'm not crazy about putting specific bequests in wills. It does sort of bog things down. If that gift is no longer there, if that piece of jewelry or that artwork is no longer there, there is no right for the executor to be able to substitute that gift. I do try and counsel, again, depending on where everybody is in the age spectrum, that if you're on the older end of that spectrum, to try and gift out if there are things like your china and your silverware or glassware or something like that that you want someone to have. It's actually better to see them actually utilizing it. So when you go over to their house for Christmas dinner and Thanksgiving dinner, you actually see it in use, and there's a little bit more joy in that than getting it at the end. I also see, doing the estate work, I see a lot of horse trading going on. So I see people who were supposed to get certain things at certain times saying no, they're not interested in those gifts, and then there's horse trading going on amongst the beneficiaries anyways. So I try and tell the clients to limit that. There might be specific property that you do want to transfer over to someone else, but I do say take a second sober thought on that before you actually include it in the will. That would probably be the number one thing about why you'd have to keep coming back and seeing me, because you'd say, wait a minute, I've decided that I want to increase that chunk of money that I want to give to the grandchildren. Instead of $1,000, I want them each to get $5,000. Anytime you want to do a change, of course, we're going to be going back in and editing the will or doing a codicil for you. So the last part of it would be the residue of the estate. So that's all the things, again, the residue would be the things that didn't form part of that joint survivorship category or the designated beneficiaries. And then anything else you have left over is what's going to be the residue. And then that's where you're going to describe who your beneficiaries are. And then, of course, who is to receive what out of your estate. There are some subject tos, though, and of course, you're still subject to making sure that you provide sufficient funds to your spouse and or your dependent children. Dependent children would be those under the age of 18. There's a new category of 18 to 22-year-olds that are going to university full-time and, again, are still relying on you for their financial livelihood. And then, of course, children 18 years of age and over who for disability reasons aren't able to earn a livelihood. So there are some laws still in effect that make sure that those groups of people deemed to be your dependents are still provided for underneath the will. There was also another big change up, which was they were finding that there was some inequities that sometimes if the clients had divorced, if you'd actually divorced the moment before death, that if you were in the divorce situation, you would have received more money than you did underneath the person's estate. And so the law said, wait a minute, that can't seem right. So they've adjusted the legislation to basically make sure that you're not going to get less than you would have otherwise got by law going through a divorce, again, moments before death. Yes, question back there.
Yes, I recognize there's quite a range, but what would be a typical time frame from death to the executor saying, I'm done?
For the completion of the estate?
Yeah.
I would say you're looking at least a year and a half. You can get a lot of that work done up front. The grant process through the Calgary courts was taking, I was telling Trevor, was taking 12 to 14 weeks. So you're talking about a 4-month to 4.5-month time period. So for the grant applications we were doing in September, for example, I wasn't getting those back till early January. The courts have now incorporated a bunch of procedures now. Today we went to a little seminar where the justice who looks after estate work says they're now down to a 5-week turnaround time period. So they've really closed the gap on that. The reason why it is a little bit longer, you might not be waiting until that year and a half to do distribution. You could do interim distributions along the way, but probably it's going to be about a year and a half by the time you figure out and finalize all the taxes, because you're going to have to file an individual return for the person for the year of death and probably an estate return for them as well. And sometimes you get looped in to having to file for the next year, for example, before you can get your clearance certificate. So again, you could do the bulk of the distribution. If you thought it was a touchy estate, you would wait 6 months for the limitation period after the grant was issued before you do any distribution. If everybody seems to be on the same side of the page and it's all straightforward, then I'll counsel my clients to go ahead and do interim distributions prior to that 6 months. And then, of course, from the 6 months forward, I always tell you to hold back a little bit of money depending on what advice you've been getting from your accountants to determine what you think your tax liability is with the government and to make sure you've held back sufficient funds to pay off that to get the clearance certificate at the end of the day. So realistically speaking, a year and a half, but the bulk of the work is going to be done in that first 6-month time period. Yeah. Yes, at the back.
You mentioned making amendments to your will. Are you free to do this yourself by changing it and signing it and adding it as an amendment to your?
Absolutely.
To you can. You don't have to take it back to the lawyer again.
No, you don't. There's just a caution. I just have caution and that red exclamation point. You have to be careful about how you're doing that codicil, because if you use the words at the very beginning of that codicil or that amendment, a codicil is an amending document to the will, and you use words that says, this revokes my previous will, because that's the first line that's in the wills that I draft for my clients. I'm revoking my previous wills or any codicils that I've made. You've now wiped out your will. Right, so yes, you can do it. It's called a holograph will, basically, or it would be a holograph codicil. And essentially, as long as it's dated in your own handwriting and signed by you, no problem. Someone will have to attest to your handwriting at the process to say, yes, I've known you for this many years and I can attest that that's your handwriting and that's your signature. So the caution is be careful about where you're saying you're intervening in the will, because if you have this nice will that's been laid out for you, you have to determine at what stage or what paragraph are you now interceding this gift to without wrecking the rest of the distribution. So that's the part that I caution the clients about. But I'll often, with clients who come in, if they're talking about, well, we do have a bunch of furniture and jewelry and things, and no, we don't want to encumber the will with it, but we do want to do this separate document, I'll often kind of give them a pro forma and say, okay, according to the will that I've drafted for you, if you want to start giving specific gifts away, this is how it's going to be laid out. And I tell them, and I give them the pro forma and then say, go to town now and write all the things that you want to write down there, so that, again, it's not inside the will, but it's in this alternate
I have that form, and I did it for my mother-in-law many years ago. It was not an issue, and it never did become an issue, but I've often wondered if it had, just because she just wanted something changing in a paragraph, and I helped her with the wording, I witnessed it, and it never came to pass. So I'm just moving on and thinking of some other circumstances at this point.
Again, the other caution is you see wills kits, or if you have kind of a document that's already partially printed and you're filling in blanks, the rules change. That's not a holograph document anymore. A holograph document is in your own handwriting. And so the moment you have a pre-printed form where you're now handwriting in certain blanks, the witnessing changes on that document, and you're supposed to have two witnesses who would not be somebody named in your will or the spouse of a person that you've named in your will act as the witnesses. And those one of the two witnesses, after you pass, is going to have to sign an affidavit saying, yes, they did so see you and the other witness and themselves all sign the document at the same time. So the court has also included in the recent amendments, there are some rectification provisions. And I got to say, before these came into play, it was hard if there was a typographical error or just an error, which everybody said the interpretation is just wrong. That's not what was meant by the whole thing. There's now rectification provisions in there. And so, for example, last year I was probating an estate. The lady had owned 5 pieces of land, and they were farming lands that have been in her family for generations, gone back to her grandfather even. And the lawyer, unfortunately, it wasn't me, so you learn by someone else's mistakes. They had entered the wrong legal description. And so if you guys are familiar with a legal description, it would say section 13, township 27, range 24, west of the 4th meridian. And they had inadvertently put in the wrong township. So we had, out of the 5 pieces of land, 4 of those 5 owned by the deceased. The other one is owned by some whole different company, not even related to the deceased. And it was just simply a typographical error in the will. So I did do a rectification application to the court saying, here's the historical title on that piece of land that she never owned. Like, we can go back in time to say she never owned that, so she never had it to give away. And that they really meant this one, and showed a historical title on that. And based on the fact that there was a will that had been created and properly attested to and all that sort of stuff, we got that typographical error rectified without a problem. So there is the ability to try and do these rectification. But of course that slowed the estate down. It slows the process down a little bit, that sort of thing. But yeah, you can do your own will as long as you've dated it, all in your own handwriting, signed it. That's a legitimate will. Again, there will be somebody who's going to have to attest to saying that is your handwriting, that they knew you well enough that they know that is your handwriting. Okay. So the other way is if you died without a will, which is not any of you in the room, but of course for those friends that haven't done them yet, out of that 44%, you can tell them you got to go get your will done. But if you die intestate, that means you've died with no will. Again, a similar situation, you are legally required to have your expenses paid, your debts and taxes, and then your residue again. So again, distributed in accordance with the Wills and Succession Act. So there's a scheme about how that gets divided. If you haven't put it in a will, then the scheme underneath the act is how your estate gets divided. So that kind of takes us through the wills part. I want to just touch real briefly on enduring powers of attorney. So an enduring power of attorney is a document. I always talk to clients and say, we all know what the will's for, but sometimes we don't know what the enduring power of attorney and the personal directives are for. And those are documents that take effect if you lose capacity. And I don't pull any punches. I call it legal insurance. You may not ever have to utilize these documents, and you think, darn it, I paid for those things and I never had to utilize it. And I say, good for you, because you don't want to be in that situation where your documents did have to be used, because that meant you became incapacitated one day. This one, sometimes depending on who the client is and again what station they are in life, if I have a young person come in and they're 24 and they've got their first job and they're making a lot of money, and they're talking about a will, but they don't have a spouse and they don't have any children, and they're saying, oh, I think I should get this will done, but they only want to do one document, I actually talk them out of that probably. I say, if you're only going to spend money on one document, I'm going to put you into the enduring power of attorney, because if you're 24-year-old and you're telling me you've got a big dirt bike and you like to go out and you like to race around, then I'm thinking you might be a donor cycle out there. And so I think you should be under the enduring power of attorney situation, because the intestacy part underneath the Wills and Succession Act will handle who's going to get your estate, which right off the top, for someone who was single with no children, would go back to their parents, which is probably where they wanted it to go in the first place, or would consider it. But I think what's more important is that person becomes incapacitated. Again, we think of a short term or a long term being incapacitated if they've had an accident where, again, they are physically eventually rehabilitated but not mentally. I mean, they could be in that state for the next 40, 60, 80 years, depending on their age. So this document is the one that allows you to name someone else to act on your behalf to handle financial affairs while you're incapacitated. And again, that can be a short-term type situation or a long-term type situation. The important part for me is that you don't get the court intervening in your financial affairs, because if you don't have this document and someone now has to apply to become your trustee, then they've got to do that through the Adult Guardianship and Trusteeship Act, and they have to get a trusteeship order. And now you're beholden to going back to the court and having to report back to the court maybe every 2 years, 4 years, 6 years, depending on what the situation is and what type of assets you're handling for the person, to having to go back into court and reporting. That's a lot of time on your hands, and also cost-wise expensive to, when I refer to the estate of the incapacitated person that's no longer able to act. So that's the enduring power of attorney. The personal directive is the document that says you've lost capacity and you're now going to name an agent to make personal decisions about yourself. And personal decisions are going to be things of a non-financial nature. The major one, obviously, that everyone's going to is medical decisions, but it also has to do with accommodation and whether you participate in any kind of employment or social or other educational activities, which can include rehabilitation program, and any non-financial legal matters. So again, the thrust of this document is obviously for the fact that you would want it in order to have someone else make medical decisions about you. And yes, the hospital is not going to leave you sitting there and not ask somebody, if you don't have a personal directive, are they going to get instructions from your next of kin? Yes. The question is whether it's confusing to the hospital about who your next of kin is. Okay, so if you have a couple of kids out there, they better be all on the same side and agreeing to the same things, otherwise the hospital can't act. But if you have the personal directive, then of course you're naming who you want to act as your agent while you're incapacitated. And of course you can have the documents come into effect, again, only when you lack capacity here. So, you know, they can't come into effect otherwise underneath the personal directive. So there's a bit of a chart, and then what I think is a better way to look at it. You get an enduring power of attorney, which you have the control over drafting, versus a trusteeship order by the court. Again, you have the ability to draft your own personal directive versus getting a guardianship order by the courts. And so I put a little chart together, again, to sort of say these are decisions that you can make in advance about who you want involved in your financial and your non-financial affairs, versus someone having to step forward and make that application to the court, and now the court giving orders out about who's your trustee and who's your guardian. And then just some general information. This is just some flags for you about when you should update your will, enduring power of attorney, and personal directive. Again, they've changed the rules about marriage and divorce now, but at any time you're changing your marital or single status, you should be thinking about reviewing your documents. Obviously, children or grandchildren may affect that. Deaths of beneficiaries, executors, attorneys, or agents. So that would be the big thing to get those changed. And change in financial circumstances, relocation to another province. So of course we've got a lot of migration in between Alberta and BC. Every province has their own legislation. It's not federal legislation, it's provincial legislation. If you do a will here in Alberta, is it invalid if you then become permanently resident in BC? No, it's not. Your will doesn't become invalid, but now you might be stuck in both jurisdictions where you have to go get your grant of probate in Alberta and then ask for what's called a resealing application in the other province. So if you know you're permanently going to be relocated somewhere else, I do recommend to my clients, again, to do documents within the province that they're permanently located. So we'll go on to the personal representative. So again, remember, this is the old-fashioned term of the newfangled term of an executor and executrix. And the personal representative has a bunch of duties, and they're governed by several statutes: the Estate Administration Act, Trustee Act, surrogate rules, and the actual contents of the will. Yes?
Quick question on the previous page.
Yes.
Update the will. Is it necessary to update the will to the death of a beneficiary?
It depends in your will. If you've named what happens to an alternate, so if that beneficiary predeceases you, and you then say, so I call them the if-then statements. If this person predeceases me, then their gift goes to so-and-so, or their share of the residue goes to so-and-so, no problem. As long as you have the alternate named in the document. Yeah, then you don't, then you've done your job.
You have several beneficiaries and one of them passes. Does the residue then not simply be divided among the surviving beneficiaries?
It depends, because your will's actually going to dictate that, whether it forms part of the overall residue. So if you had 5 beneficiaries and one's passed away, then do you have it split amongst the 4, or does that person's share now get redistributed somewhere else to their children, for example? Like if you had 5 kids and you said if one of the kids predeceased you, then they're drafting the alternative as their share goes through to their children in equal shares. Because if you think about it, if you don't keep that lineal descendancy line going in your drafting, you've now cut out that 1/5 of your whole estate, and that's divided up amongst the 4 remaining kids. So that means one of your kids and their family get completely left out of your estate now. So your will have language in there to determine what happens. Yeah. All right, so in terms of the personal representative, these are just some general duties. Again, these are all sort of codified in the acts, but obviously the person that you want to name as your personal representative should be the person that's going to act honestly and good faith in relation to your estate, and to follow your intentions underneath the will, and make sure that they have some care, due diligence, and skills that they would bring to this type of relationship. So it's called a fiduciary relationship because they're the person that is looking after your estate. And then, of course, their job is to make sure they distribute the estate as soon as practicable, subject to, again, limitations and income tax rules.
And that person can be a beneficiary?
Yes, absolutely. Your executor or personal representative can be a beneficiary. And I would say most of the time I see that in the wills. They would be definitely receiving both. And then, of course, their core tasks. This is just mainly for your information's sake. This is the part that Trevor talked about, identifying the estate's assets and liabilities. And I can't, again, speak to how important that document is. And the other thing that we touched on before and is becoming paramount is your passwords. And we didn't talk about it this go round, but I can't keep track of all my passwords. It's crazy, right? You have to have some in your binder with this document. You better have some passwords down, because so many people now are doing online banking. You don't get bank statements. You used to be able to say, hey, wait for a month or 2 worth of mail to come through, and you'd see, oh, well, here's a TD statement, and here's an investors group statement, and here's an RBC statement. If you're all on online banking, you don't even see statements anymore, and now you don't have the ability to even get in online. So one of the first things that I talk about if someone doesn't have that nice list put together is to go back to the previous deceased income taxes that they filed for the last year. So if they filed their 2016 taxes, go back to that taxes, because at least you might have a T1 slips and your T4 slips, your T3 slips in there. You'll have some sort of slips available to kind of start tracing where these assets come from. But now we're getting into this dangerous zone, just because you can show, hey, this person had an iPhone and I'm pretty sure they stored everything in that iPhone. If you don't have their password to get in that phone, you've got to get a court order to get that unlocked. Apple is not going to give you that guy's password to get into his phone to go check it out. Again, a lot of people will have their phones that they use as part of their work. That's not their property. They have the use of that phone while they're working, but that's not their property, so that phone's going to go back to their employer. So keeping your password book But then keeping it safely somewhere in your house, you got to kind of juggle that a little bit, and I still sort of struggle with that. But I don't think people are going to break in my house and get my passbook. I just fundamentally don't believe that. I guess I just don't think there's that much crime going on here in Canada. But to me, it's worse that you didn't leave some information to the people that need it when you're gone. So think about the passwords and how you're going to handle that. I have a very unfortunate scenario where I drafted a will for a lovely man, and he came in to see me a couple times, and he probably died with about a $2.5 million estate. And the way he wanted to line it up was he had 2 sons, and the one son was going to be a half beneficiary and the executor. The other son was simply going to be a beneficiary, but the first son, who was going to be the executor, was going to be the trustee over the other son's money, because the deceased didn't like the way that the other son handled his financial affairs. So he wanted to kind of do a little controlling from the grave there, which was fine. There were reasons with that family about why it was set up that way. The gentleman passed away last year, later in the fall, and nobody can find his will. So we have a little bit of an issue about proving that. So I went back to talk to them, and I said, well, the will was handed over at the time of the appointment, and I give all these instructions. Make sure you go put it in a safety deposit box or another safe and fireproof place. And I had to sort of waggle my finger, because I thought to myself, you've got a $2.5 million estate with some very peculiar terms in it. Your will has gone missing now or lost along the way, and why isn't it in a safety deposit box? Because maybe it cost $100, $60, I don't know. Some of them are free when you're seniors. And why you don't have that box with your will in it, if that's the only thing in there, well, that's still a good expense to have, because now we don't have your will with this very specific clause that you wanted in it. So that entire estate planning went out the window because we don't have the will to go probate at the end of the day. So again, this is more just information for you guys to take home. I don't want to bore you with all the details there. I do want to talk about compensation. So there's kind of like everybody panics about, well, this is going to cost a lot of money, and you talk about this probate and how much is this going to cost. So there's the personal representative is entitled to seek compensation for acting on the estate. I got to tell you, with the majority of files that I deal with where it's either spouses or children that are named as the personal representatives and beneficiaries, I would say 90% of the time, nobody asks for $1 of compensation. They just do it. It's a matter of course. It's a family affair, so they're just doing it for the better of everybody. Now, that doesn't mean that they're not getting reimbursed for their expenses. Obviously, they're going to keep a checklist of all their expenses and be reimbursed for expenses, but I got to say, on the whole, my clients don't ask for compensation. So it depends, of course. Compensation is more of a subjective test than it is an objective test. So the subjective nature of compensation is, what's the total value of the estate? How much revenue and disbursements were you dealing with? The complexity of the work, how much time, labor, knowledge did you need in order to deal with the person's estate, the time expended, and again, the complexity of the task. So all of that's looking at a whole, and then there's always a range. And so I put in the suggested fee guidelines so that you guys could have an idea of what the actual range is there, and it depends on whether they're dealing with the capital, the revenue, and then the care and the management on that estate. So, you can throw in your own net value of your estate and kind of run those percentages to kind of say, oh, well, is that what I'd really want to put in my estate if the person could ask for 5%? Of the first 250, and then another percentage over top of that 250. Again, most of the people that I'm dealing with, we don't ever look at this guideline. If the few cases that I've had where people are asking for compensation, it's a very reasonable sum in relation to the work that they've had to actually do. So you have your personal representative's compensation or fees to think about. The other thing is the filing fees when you have to go get this grant of probate. And I talk to all my clients about this. We unfortunately get all our news often from Ontario or BC, and they are constantly telling you how to avoid probate. Do those words sound familiar to people? You should avoid probate. This is some terrible process. In Alberta, it's not, and it's not because our filing fees to go get this grant of probate are so minimal. So what I wanted to show you guys is just the gradation of the filing fees. So, you know, if your estate was $125 to $250, you're paying $400 for a fee. Anything over $250, you could have $6 million and you're still paying $525 to the court. Now you can still say, well, that's $525. In these other provinces like BC and Ontario, it's a percentage value of your estate. That's why they keep telling you to avoid probate and to do things like, hey, why don't you put the house into your name and your kids' names? And by the time I get through a 5-minute conversation with my clients, they say, that's a good idea. We're not going to put the house into our names and the kids' names because that child could have creditor problems. That child could get divorced. You could not get along with your kid at the end of the day, and you don't have an agreement about what you should sell the property for or how much you should sell it for. You lose potentially your tax-free status on it being your primary residence because now you've got 2 people on title instead of just 1 person on title. So there's lots of reasons why I tell my clients, no, avoiding probate is not necessarily the right direction. So that's the filing fee with the courthouse. Again, maximum value is $525. So I got to tell you, I don't know, I can't say across Canada whether that is the cheapest filing fee, but I can tell you it's one of the lowest filing fees. And again, it's not a percentage value of your estate, which in these other provinces is absolutely like unreal. It's a taxation, and there's been lots of case law on that where the courts have found that it walks and talks like the duck. It's a tax, and somehow the province keeps revolving around and still being able to do it. But that's the other provinces. They've got their problems. The third kind of compensation is lawyer's compensation, obviously, because maybe you don't do your own probate, so you hire a lawyer to actually help you do the grant application. And I'm sorry, I do have a typo in here, so get your pens out. Because there's 2 ways to compensate lawyers, generally speaking. There's probably multiple ways, but the 2 major ways would be the suggested fee guideline. And so where the typo is, it says on estates with a gross value of less than $150,000, the suggested fee guideline is that the lawyer charge $2,250 plus and the estate value. And so on the estate value, I've got 1% there. It should be 0.5% on the estates that are under $150,000. The second part of it is if you have a gross value of your estate over 150, which would probably be everybody in the room here, it's a base fee of $2,250 plus 1% of the estate value. Remember, it's gross value. So when you do your computations again and think, hey, that 1% of whatever your gross value of your estate is, that's a large sum of money for a lot of people. So I was never a fan of this. And when I started doing my estate work, it was for extended family members. And I just didn't feel like the percentage was the correct way to bill people. So the other part of option 1 is, in addition to that, you can also pay the lawyer for hourly fees and paralegal fees for what they call non-core legal services. So in addition to that, there can also be you getting charges for non-core legal services. And of course, GST and disbursements are added on to everything there. Disbursements are things like the court filing fee and mail and photocopying and searches that have to be done. So those are like third-party expenses. So that's option 1. Option 2 is, I took the approach of keeping it simple, and that's kind of my mantra about how I run my practice and also my life. And I just do it based on my hourly rate. I'm going to charge you for the work that I had to do in relation to your estate. So again, one of the first files that I worked on was a lady's estate, and she owned a house in Mount Royal, and she was house rich and she was cash poor. And I didn't feel that at the time of her death, her house was worth over $1 million. She had very little in an actual bank account because all her asset was in the house. And it was a very simple and straightforward estate. And I didn't feel like I should be charging a base fee and a percentage fee on that simply because she was lucky enough to have a house in Mount Royal that had increased in value over time, over her lifetime. So I have to tell you, it's probably the 90-10 rule. 90% of the time, I can tell you my hourly rate is far below that percentage, like grossly below. And I show the clients that when they come in to say, this is what the bill is, this is what it would have been if I charged you under the guideline. And then the other 10% of the time probably means that there has been an awful lot of work to do for a very small estate. So somebody who had an estate under $100,000, but it's really complicated. They died in an accident. We have to note they had no records to look at. We had to do a ton of work behind trying to find out where the assets were and where they were held. A lot of lawyer involvement in that. And so that's the 10% time where the hourly rate was higher than the actual percentage part. And it's when the estates are complicated but don't have a lot of money associated to them, but we still have to go get this grant. And then of course the GST and disbursements are added on to that. So I wanted to show you the sort of two systems to educate you as to when you do talk to lawyers, if you have to do that in relation to somebody's estate, you should be asking about how they actually bill on the estate and which system they use, okay? I think that was all that I had to talk to you guys about, and I don't know what we're doing for timing, but I'm open to questions.
Good, thank you.
Question?
This may not be your actual area of work, but when it comes to probates and wills, and the original will can't be found, and you take a copy and you give it to the judge, how does he verify that as that's going to be the will, that is the will, and he's sure that it's it?
There has to be, so there's an actual application now where you have to get the copy codified by the court, essentially. And that process is going to require that there's a bunch of affidavits to try and talk about, again, if the person did the will in front of the lawyer, then that lawyer can testify to say, yes, on February 13th, 2018, I did see that person sign this document in my office with my paralegal. So at least you have a starting point that says that will was originally signed at some point in time. And then you're going to have to provide some sort of facts to the court about from the time it left the office, what happened to it at that point in time. Now, there's a lot of case law out there, and the case law is very specific where courts will accept copies. So most of the time, just saying you lost it, it's probably not going to help you out in terms of an application. Again, there's going to have to be some sort of specific circumstances. So there is a case like out of Saskatchewan, for example, where the lawyer went to the hospital, drafted the will for the client and had it signed, put it in his briefcase, threw it in his car. The car got broken into and they stole the briefcase, which had the will in it, and the gentleman died about 3 days later, and they didn't have time to get back up to the hospital to get instructions. And so the court found, obviously, the continuity of that. There was no opportunity for the will to be redone, and they knew the circumstances behind it being stolen in the briefcase, never to be found again in the car. So there's some very specific facts behind that case. But just saying that it's floated out there, the problem is it becomes a reverse onus. So the party who wants to say that copy was really the original will, and we're sure that the person never changed it after the day they walked out of that lawyer's office, you have a reverse onus, and you have to basically establish to the court that they didn't otherwise go change their will, because otherwise if you can't find it, the law basically says then that means it didn't exist, because they might have thrown it out, ripped it up, destroyed it. So there's this concept that it's been destroyed if you can't find the original one. Yes?
For an amendment to a will, or even a review of the will, is there any obligation to deal with the same law firm that originally constructed the will?
No, it's free to go. Yeah, free to go wherever you need to. And when I'm doing a situation like Trevor mentioned, the client that he reviewed the will on, and it's from 1969, it's the same thing. I've reviewed clients' wills done by other lawyers, said it is fine, checked out some circumstances for them, said, are these things still true? Yes. I said, well, you don't need to change your will. So I'll look at it. The law there was a long period of time where the law hadn't changed, and it was very static. And then with the recent amendments back from 2015, there has been changes in the law. So I would look at those to determine if those changes in the law had affected the drafting of the will. But again, it's those qualifications that I put in there about single, married, divorced, separated, those kind of things, adding more family members, again, changing province of residence, that I think is the most important one. And I will just say one other comment, and that's the BC rule. So I had someone contact me The mother passed away in early of 2017, and there were 3 children, and unfortunately, one of the 3 children were not included in the will. Those were the instructions that I had. There were reasons why the person wasn't included. They'd got other monies from mother during their lifetime. So, quote, she cut him out of the will. And I was contacted by a lawyer out of BC not more than a month ago that said, hey, I want you to prove your probate, and I don't know what's going on here about why this person wasn't included in the will. And that is called Alberta's testamentary freedom. You are free to put whomever you want in your will with whatever beneficiaries you want to do in there, with the exception that you have that dependent category that I mentioned, right? Spouse, and then the specific children category. In BC, they have a Wills Variations Act. So that lawyer was like, and we're going to take an application underneath the Wills Variation Act, and we're going to get that will varied simply because the child had been, the child, who was an adult child, had been cut out of the will. And I, kind of wrote him back a letter saying, well, good luck with that, because we do not have a Wills Variations Act here in Alberta. That act scares me, because it allows the court to go back in BC and then maybe rejig what you as the testator of your will had already wanted to write down. There are specific reasons why, again, this child wasn't included in the estate. But in BC, they would have taken a run at it. And I think he would have taken a run at it, but she was normally resident here in Alberta, and I drafted the will, and we're probated and we're good to go. So I said, well, good luck.
Just to add to that, one of the most important things is your will should never be the place where you surprise anybody. So if you have disinherited a child and you still talk to that child, like if you haven't talked to them in 30 years, you don't have to let them know. But if there's a specific reason where you give them bequests or other things, they do not want to discover in their will that they're not getting a share now, right? It's never a place for surprises. So a will is an extension of good communication. So if you don't have good communication, you want to find ways to do that, it's a terrible place to surprise people.
Yep, true on that. We wouldn't have disclosed in this particular
in that
case.
Case,
Yeah,
because there wouldn't maybe, it wouldn't have been a relationship for a specific reason, but it's always...
Mother saw this coming, I think. I think that's what I can honestly say.
Absolutely.
Yeah.
If there are no other questions, thank you, Kathleen.
Oh,
thank you, Trevor.
Wait a minute, one more,
I
Chris.
beg your pardon?
So how big is your team, or are you working on your own with paralegals?
I'm working on my own as a lawyer, but I have 2 paralegals. And so, I am taking on an articling student to give them a helping hand for 8 weeks. So I'm going to be a mentor now for 8 weeks coming up here in the latter part of February. So.
Oh, great. Okay, so if we contacted you for services,
yes,
would it be a couple weeks out, or?
Yeah, usually the rotation time. So on the services, it's usually about a 2-week rotation time, but of course that juggles. If I've got somebody who's gone into or is about to get transferred into hospice, sorry, that person gets my full authority, my full attention type thing. So, but yeah, usually it's about a 2-week turnaround time.
Thanks.
Yes.
Oh, sorry, one more. Are there differences in treatment between married and common law?
Yes.
Usually?
Yeah. Yes. So you do, if you're common law, then I strongly encourage you to get the will done, because there is differential treatment. And if you're the only person on the house and you live common law, that person doesn't have the right, has no rights on that property. They don't have what's called a dower act on that. So if you're legally married but there's only one person on your title, then your spouse automatically has a dower right. So that's a hovering right over the property. Before you can go sell it, you have to go deal with your dower rights. But underneath common law, you don't have a dower right. So then they can deal with the property directly without having to worry about the common law spouse. Thank you, David.
Thank you, Kathleen.
Thanks, my pleasure.
Thank you, Trevor. Kathleen, I got one question. The filing fees?
Yes.
Any word that Alberta's going to go the way of, and how long have those been in effect?
Well, they got increased a little bit in 2015. A good question, because I don't like increasing fees, but if I were the government, I'd be increasing these fees and the land titles fees. You gotta get your revenue from somewhere. So I'm surprised that they haven't been touched yet. And I'm waiting for that. But I think if the Alberta kind of philosophy again is, if you wouldn't see it kind of go up 6 times or go into a percentage, I think you'd see it maybe go into
doubling those fees. If we even got to 1,000 being the top fee, that's still unbelievably reasonable. It's supposed to be a fee for the service that the court has to provide to do the work. That's how the fees are supposed to be issued here in Alberta, not the percentage basis. But don't forget, if you have properties across both borders, you do get stuck in BC. If you have a secondary residence in BC, you're going to be paying their percentage fees for their probate.
Thank you.